What's her name?
It's not the original.
No, Candy Staten.
Okay.
That's her
Who
name.
was it?
I want to say it's Candy Staten or Stanton.
It's like a one hit.
Yeah. No, she has some other hits. Yes, but I love that's a beautiful, I mean, the way she sings, I Can't Stand the Rain. Other people have sang that song, but she sings it very well. But hey, rain, rain brings flowers. How can you not like the rain? All right, thanks. Oh, Vashon, did I tell you there was an accident on my way in? No, okay, this is what ends up happening. There's this guy in this F-150 and it's high up off the ground. And I do not speed in the school zone. It clearly says the speed limit is 20. So he's riding my bumper. And then he moves over to the other lane. And when he moves over to the other lane, he ends up hitting someone. So I'm just like, But I really wish people would pay attention to school zones. And they don't have crossing guards at every corner the way they had when I was growing up. But I was able to get my plants down, so this rainwater is going to be great for them. Hello. Good morning. All right, it is 9 o'clock. I'm gonna call the docket. And when I call your name, you need to let me know you are here. If you don't answer, I'm going to assume you're not here. Please stand when I call your name. Juan Antonio Garcia Sanchez. Jaden Green. All right. McDelia Salazar. Fidel Ayala. Darren Doze. Brandon Sierra. Elsa Vaquera. Philip Diller.
Morning, Judge.
Hello. Arnold Garza is in custody. Stevie Ray Stokes. Thank you. Carlos Salazar. Satira Portillo. How do you pronounce that first name? Satira? Did I pronounce it correctly? All right, thank you. You'll see Mr. Porter didn't say, well, Judge, this is how you pronounce the first name. He's like, I'll locate him.
That's what I do.
Francisco Luna. Francisco Luna. Actually, I don't think it says he is to be present in court. All right, Melvin Hernandez is in custody. Lindsay Pierce. Thank you. Alfonso Diaz is in custody. Is there anyone who came in later? Your name was not called. All right, we got a lot of people. Oh, I know you're here. Oh, you know what? I'm sorry. There's another page. Julio Zavala is in custody. Manuel Mendoza. Santuan Wilson. Manuel Rodriguez. Thank you. All right. Is there anyone whose name was not called? Yes, sir. Albert what? All right. Do you know who your attorney is? Meadows, Larry Meadows. All right. Do you know your SID number or case number? What is your SID? 1012303. All right, thank you. Anyone over here? Yes. All right, are you a defendant, witness, attorney? Who are you?
Make a claim on this and see you this week.
Okay, all right, just have a seat. We'll get you as soon as the attorney comes in. Come in. Hello, what's your name?
Alexandra Alvarez.
All right, are you on the docket today?
Yes, ma'am.
All right, do you know who your attorney is?
I do not.
Do you know your case number or SID number?
No. I can get it though.
All right, here's the thing. You're in felony court. Serious things are happening here where people could go to prison for life or even get the death penalty. For everyone, when you are accused, you should definitely know your attorney's name because many things happen here. All right, this is the schedule for today. We're going to finish a bench trial today, and that bench trial will be finished today. If that bench trial is not finished today, we're still having our jury trial today. So nobody assume that because we're in the middle of a bench trial that has one witness remaining, that somehow your trial is not going to go. Your trial is going today. These are the rules of the court. There are files for criminal trial division over here. Family violence files are here. Someone who's on the family violence docket today, which is are your sex cases, child cases, assault cases, is going today. Just grab your file. The prosecutors will confer with you. Do not approach the court unless you've conferred with the state and conferred with your client. If your client is in custody, they need to be brought out. Once your client is brought out, please do not leave because that's a little bit selfish to other attorneys. Because of security reasons, the deputies can only bring out so many clients. If your client needs an interpreter, do not approach the court, and you're not ready to approach the court until that interpreter is here. Once that interpreter is called, do not leave the courtroom because there are so few interpreters and they have to be in a lot of courtrooms and they're only here for like 5 minutes or so. However, if you're one of those people in jury trial, don't worry, we will have an interpreter for the full length of the trial. Do not approach the court coordinator asking for a continuance on your case or a reset. I'm the only person who can give you that. Every case that's on this docket today is subject to being called back for a jury trial today. So with that being said, I know it's raining outside, but without rain, you can't have flowers. And Robert Porter, my understanding is that rainwater is the best water for plants anyway. So it's great. We're all here. Everybody made it safely. So please confer and be patient and kind with each other. Thank you. Deputy Laura, I'm almost done with my cozy mystery. I'm going to see if who I suspect did it is correct.
I don't do that.
I don't know. I think there's other days. I love it.
Oh, yeah. All right, is the other court not available?
They're not here yet.
Yeah. We were just gonna see like what the judge said about.
Yeah.
Like, I don't know if we. Do it or-
But I think for you.
See what she does.
Melvin Reynolds.
What time is it? Oh, four. What is that?
All right, can I see the officer? Good morning. Great. Is all correct and within your personal knowledge? All right. You're welcome.
It's Jane Green, first row, the next side.
Been on with this like, what happened? Season.
Maybe you just need two.
There you go. You're welcome. You too.
Yeah. just like we're right.
So what,
Bodies.
the Tadia?
Yes.
Okay, thanks. All right, hi.
Yeah. Good luck next time when you try to pronounce it.
Oh, yeah, I'm gonna work on it.
But that one.
So.
You have Medallia, and Medallia's all the time. And yes.
I mean, I look for Monica. I think she's got somebody.
Just Medallia's fine. Yes, absolutely.
That's fine.
So it's fine.
Okay.
All right. Migdalia Salazar.
Good morning, Judge.
Good morning.
Hi, so I'm with Joseph Holscher on that case. We picked a jury in the 144th yesterday, and the jury's panel is coming back for us now. So
Okay.
we requested.
And what trial are you picking?
We picked the jury. It's on Blaine Bozeman is the case. Or
And which court?
144th,
I like to put everything on the docket sheet.
Judge Mary. There's a companion case to that. It's Fidel Ayala. Monica Guerrero is representing her. I believe she picked a jury in 379th yesterday.
Are
as
you here to
well.
make
So
announcements for her?
it's a companion case, but
Yeah.
I'll let her handle it.
All right. So it is the ninth. All right, so we're recalling this for May 23rd. Could I have a reset form, please? And it has Bobby Gibbia as the attorney.
I know we filed a motion for substitution on that. but we'll-
Could you check the system, please, on 2021 CR 9849 and see who's listed as the attorney, please?
Yeah, don't say any anyway.
Yeah. 2021 CR 9849. Yes.
Look at it.
I'll get that corrected, Judge.
All right, so do we have forms for notice of retained counsel?
We do, Your Honor.
And Judge, I do believe that Mr. Holscher is starting a 2-week civil trial on Monday. That would, I believe, go through the 23rd, but we can.
Yeah, no, he's gonna be in trial in here because this case, it has 12 settings for trial. here. Do we have that form or no? All right, so that form, All right, thank you. No, this isn't the correct one. Council, I'm gonna need a notice of retained counsel on this by today. And I don't know if other courts have one. I don't know. There may be one on that box over there. Or either in the back. All right, have your client sign that. And turn, I'll need the top copy. You probably need to walk around. Unless your arms are long enough. All right, thank you. There you go.
How do you help them pull about? I think this is file 13. How about the next?
Manuel Rodriguez. All right.
Good morning, Your Honor. Are we on the record?
No, we're not on the record yet.
Could I request that we be on the record? It's a motion for continuance that I'm asking the court to consider.
All right, are you the attorney on this case?
I am not, Your Honor. And that's part of the basis for the continuance.
Who's the attorney?
Lee Cutter's the attorney of
And where is
record.
she?
She is on her way to Guadalupe County for another criminal matter, Your Honor, and she's going to be there probably the majority of the morning. And then in the afternoon, she's specially set in front of District Judge Forte.
Okay, well, she'll need to stop over here in this afternoon. Because let me ask you this,
Yes, Your Honor.
the matter that she's going to another county for, is that a jury trial?
It's not a jury trial to my
This
understanding.
is, she should have came here first.
I understand that, Your Honor. If I could just be heard at.
No, she needs to be here. I don't know why people are thinking that this is not a criminal district court and that attorneys don't need to come here. This is a jury trial. Where she's going out of county is not a jury trial. This case, I'm sorry, sir, what's your name? Manuel Rodriguez. Thank you. Wow. This case has been set for jury trial. This is the 8th setting. So I don't know why someone would go to another county as opposed to coming to a court where they have a jury trial set. So we will not be going on the record. She will need to be here.
I understand that, Your Honor, and from my understanding of it, there was a jury trial setting in November and December, but those were actually settings for bond motions. So I don't know that they're actually true trial settings, Your Honor.
We're here today for a jury trial.
And I understand, and I did approach the court yesterday with the motion for continuance.
Yeah,
because
and I was not hearing that. I want you to hear me clearly. That attorney is in another county for a case that's not set for jury trial. This is set for jury trial this morning. I don't understand why people don't understand that, one, and I consider myself reasonable, one, that jury trials take criminal jury trials take precedence over civil matters. I don't know why people don't understand that. District court matters take precedent over misdemeanor courts. I don't know why attorneys are acting as though they don't understand that. So we will not be going on record. I will not be hearing this motion. She needs to be here. So whenever she comes back from that other county that she's in, I will hear that motion.
I understand.
And whether or not I grant her motion for continuance, I do not know. But what I do know and she needs to be informed of, is that criminal matters take precedence over civil matters. And when I give people leave to do civil cases beforehand, that's me being kind, but they don't take precedence. And so go forth and tell other attorneys that one, district court takes precedent over misdemeanors because people seem to have forgotten that, and that district court matters take precedence over civil matters. And that anytime there's a jury trial set, at least in the 187th, and you're going to some other county and that's not a jury trial setting and it's not specially set, they need to be here.
I understand, Your Honor.
All right, thank you.
Thank you.
Mr. Cox, where's Mr. Cox?
License office.
All right, if you'll knock on his door and tell him that we're ready.
Your Honor, may I approach for a signature?
For what?
A signature on an investigative motion.
Yes.
Thank you. Do you want me to call in here?
Oh, just go away.
Smoke was I like today. Oh, there's motions underneath it for the.
Okay. Yes. All right, Mr. Cox, your witness here.
I'm allowed. He contacted me on the phone, said he had a problem getting here with a ride. Actually, was okay to do it by Zoom.
Mhm.
And like we discussed yesterday,
Yeah, so is
they
he-
had no problem with it. I have no problem with it. I just need to
Get the Zoom link.
get the Zoom.
All right, Deputy Laura, could you give Mr. Cox the Zoom link for his client? All right, we'll take this up. Thank you, Mr.
Thank
Cox.
you, Judge.
You're welcome. Yes. Yes. Wait, I'm sorry. What, who do you need to Zoom in?
This is Alfonso Diaz. It's an MTR. The witness is in Massachusetts.
Okay.
I checked yesterday. They said get a Zoom link today.
All right, family violence. Do y'all have any objections to a witness zooming in on Alfonso Diaz for a motion to revoke?
No, Your Honor.
All right. They'll give you a copy of the Zoom link right here. Yes.
Thank you.
You're welcome.
I said that loud so the judge could hear it.
Yeah.
She's gonna practice rolling that arm.
All right, Portillo. Excuse me, could somebody wake up the person with the polo shirt? Sir, there's no sleeping in court. Thank you. I would love to take a nap. When it's raining, I always can sleep so beautifully. All right. And you are in the middle? I promise I'm going to work on trying to say your first name. How do you say it?
Setare.
Setare?
Yeah.
See, you pronounced it incorrectly, Robert.
The last part was wrong.
Yeah.
The middle part was right.
All right, Setore. So where did that name come from?
It's Persian, Farsi.
Ah, tell me, do you speak Farsi?
I do whenever I get in trouble with my dad. It all comes back.
All right, I knew, because I was like, I know that. So how do you say hurry up in Farsi?
Arehane, like that.
Okay, I'm gonna remember that. All right, so where are we on this case as far as discovery?
I believe I would have all the discovery, Your Honor.
Okay,
On my own side, I need to get a couple of pieces of paper from her, give the state, he's gonna give me an offer, and I think we're gonna work this case out.
okay, and so state, you gave an offer or no?
Not yet. Not
Okay.
until I provide them with-
All right, so I'm gonna reset this for, and I'm sorry, can I have a reset form? Let me see, today is Tuesday. If I reset this for June 6th, is that enough time for everybody?
Yes.
All right, so on that date, the state will make an offer and you have information to give to them.
I did.
Oh, do you have another one? This is, oh, I get that from my mom. She's like giving people wrinkled, crumpled up paper. I have to apologize to that tree. I'm sorry.
I want a fresh one because I want to refill it myself.
And I'll just set this as a discovery, but we already know what it's for.
Thank you.
All right, after you all sign this, Mr. Porter, just make sure a copy goes back to the clerk. Oh, thank you. Mr. Porter, Mr. Porter,
Thank you.
you're welcome. All right, sir, what's your name? Who's on Zoom? Anthony?
Yes, Anthony Bagley.
All right, I'm gonna need you to speak up so that we can make sure we hear you, okay?
Okay, can you hear me now?
No, if you could talk a little bit louder.
How about now?
That's. All right, try again, please.
Okay, how about now?
Yes, that is much better.
Okay.
All right, just find a stationary place and we'll be right with you.
Alrighty.
And to the, if you all could move so that the fence can sit there. Yes. Who's here on Jayden Green? Hello,
Morning.
morning. So what is happening?
State's ready, Your Honor.
We're ready, Your Honor.
All right, so what I'm gonna have you all do is come back here at 11.
11.
Yes.
Okay.
All right, thank you. All right, Mr. Cox, if you want to have a seat with your client.
Your Honor, could we approach preliminary matter before we get?
Sure.
And if we can do it without the sound, because we got a witness that's on the Zoom, I don't know if you can hear.
Oh, yeah, he can hear.
So I need to discuss some things outside the presence of the witnesses with this court and with the state.
All right, well, let's just step in the hallway for a moment. All right, Mr. Bagley, just give us a moment.
Okay.
Deputy Laura, can you mute us? Lee, I'm going to place you in a breakout room. Well, not a breakout room. I'm going to place you in the waiting room and I'll bring you back in shortly, okay? Before I do that, Mr. Bagley, do you have an attorney?
No, ma'am, I don't.
All right, so then this is what I'm going to do. I'm going to put you in a breakout room and I'm going to get you an attorney, okay?
Okay,
All right.
thank you.
So I'm going to send you to breakout room number 1 and just remain there until I send the attorney in, okay?
Okay.
All right, thank you. Mr. Porter, are you able to remain here today or you have someone else you need to be?
Checking with 226 real quick.
Okay, thank you. Family violence, you may reassume your positions. Are you already on Alfonso Diaz? We're still waiting, I guess, for your witness.
Judge, not quite.
Okay. They're not ready.
Yes.
Can I touch on Fidel Ayala?
All right, Fidel Ayala. Hello, good morning. So my understanding is that Ms. Guerrero is in jury trial?
She picked a jury panel yesterday. The 226 is resuming at 10:30. She gave us some time to go to some other courts first. She has some hearings, but we're going back to trial at 10:30.
All right, and what court is it?
226.
All right, and I have no doubt that she's in the 226, but I'd like to put everything on the docketing sheet.
Yes, Your Honor.
Could I see a reset form, please? Thank you. All right, I'm going to move you to May 23rd for jury trial.
Yes, Your Honor.
And I will give you the reset form. Once your client has signed it, just turn in the top copy to the court and then you both are excused.
Yes, Judge. Thank you.
You're welcome. Are there any outstanding discovery issues?
No, not to our knowledge. Thank you, Judge.
All right, thank you.
Just for person,
Yes.
I think I have a written. If not, it's great because I'm still confirmed with the state. If it is, I will send it.
Now you have a trial, you have a setting on Julio Zavala.
Okay.
Yes,
that's
but I
it.
don't have it as a writ hearing.
Okay, this is a 1993 case. And I was not clear if we were actually set this morning,
Okay,
but Matt, the conviction integrity unit still looking at it as a possible second campaign.
what the for Julio?
No, on a whole nother.
Okay, so I don't have that writ, so I can't.
If it's not on your docket.
Oh, no, it is Francisco Luna.
Yeah, yeah.
Yes, it's here.
Okay, so. And I can get Matt down here, but we were gonna ask for a little bit of additional time because they haven't vetted for their second chance committee.
All right, could I see the file on Francisco Luna, please? And your client was not aware of this setting because he's not here.
No, he's not here. I told him he didn't want to be here because it's a red zone.
Yeah, no, so next setting, he needs to be here. All right,
This is not a citizen. He's a little-
Yeah. Yeah.
Okay. My apologies.
oh, no problem. Let me have them pull the file. Okay.
And I was sent through that.
All right, thank you. You may or may not have a file because it's from 1993.
Yeah, you probably have to know.
Let me see if there's any paperwork on that.
Okay,
Okay.
if there isn't any paperwork, let me see. I'll give you a setting of June 6th. Is that enough time?
Yeah, except I'll be gone. It's through the 7th, because sometime after that.
All right. I'll put you at June 8th. Is that good?
Yeah.
Where are you going?
I'm competing in Scottsdale on June 2nd.
Oh my
I'm
gosh.
so excited.
I'm so proud of you for doing that. That's awesome.
I really.
No, don't be stressed. I admire the fact that you're doing that. Now it makes me feel like a slug, but you know. Yeah.
Well, anyway, so yes, that's what I'll be. So June 8th, we'll see where we are. If we have some resolution before then, we'll come and see.
Okay. All right. So that is June the 8th. And then you have Julio Zavala.
And I'm working on him.
Yes. All right. You're done?
Yes.
Oh, just tear off the top copy.
I usually just take the bottom two.
Okay. Yeah, that's fine.
Judge.
All right. You're welcome. Happy trial.
Yes.
Okay. Thank you. All right. Could I see a reset form, please? Thank you. And can you make me another docket sheet for this file? Let me see if there's room, just 1 second. Ah, no, there's room.
Okay.
Uh, Lorraine,
Yes, Your Honor.
let me give you this reset form.
Okay. Your Honor, may we approach?
Just a moment.
Thank you, Judge.
Yes. Yes, what are we approaching on?
Judge, Judge, so I spoke with Nathan Slimane. He reached out to the complainant. He said that she doesn't have anyone to look after her kids, so she can't physically be here. She can still
Well,
report.
she can bring the children. Yeah, let her know. I'm fine with her bringing children.
All right, Judge. I mean, I don't know if she's gonna still be able to. I don't know if she has the transportation.
All right, let's call and see, but tell her she is more than welcome to bring the children to court. Philip Diller. Yes.
Good morning, Judge. We're on the trial docket, and this morning we received new discovery. 168 pages of school records. We're in the process of trying to download them, but we can't be ready unless we have all that and go through it and find what is good, bad, ugly, etc.
All right, everybody come back at 11.
Judge,
Yes.
I have a sentencing at 11 in Guadalupe County. I came here first because it's a jury trial and it's a sentencing out there. I could be back at like 12 or 1.
Okay, that's fine.
Is that okay?
Yes.
All right. I'll be
All right,
back
thank
soon
you
as
for
I
coming
can.
here first.
Of course. Thank you, Judge.
Judge, you want me to go get Cornelius?
Yes, what's up?
They're infants, Judge. It's like a 1-year-old and an 8-month-old that were,
Okay, so she can't come down to court with them?
we don't, I mean, I spoke to Nathan. He said he doesn't even know if she has enough car seats to transport.
Okay, well, let's find out the information before we, let's communicate with Nathan and his client and see if it's possible, and we'll go from there.
I'm a skimmer in recovery. That's what's up.
You got a promotion this time. Yeah. Soup kitchen.
You probably was already done. I don't know that.
My first year. First rodeo. And this rodeo. This. Yeah. Sorry,
Yes.
I have Nathan on loudspeaker. We'll just wait for Cornelius. I just can't do that. I go run by, just have him come in.
So what is Nathan, what, he doesn't need to come in. What does Nathan say?
And you're here on loudspeaker with the judge.
All right, Nathan, is your client able to come in or no?
I was just hearing the judge.
Nathan, is your client able to come down or no?
Absolutely not, Judge. Not with her.
Okay, so she doesn't have car seats or anything? Thank you.
Oh. Oh, it's so cute. Can I give this to you? Yeah. Okay, let me see. I just want to make sure. Okay. Oh, I was in there. It's in my life. Just hold on.
Brandon Sierra,
Good morning.
good morning. Hello,
Good morning, Jen.
good morning. Yes,
Jen, we are ready for our interesting announcements.
okay, yes, 11, I come back at 11. Yes,
Arena, at that time, I guess, will it be determined who's number one? Only because
Mhm.
then I have to cancel something, a dental appointment. So is it, well, we don't know yet if we're number.
We don't know
one. We
yet.
don't know. Okay, okay, thank you.
all right, you're welcome.
And it was at 11, so. I'll
Yes.
cancel.
Okay.
Yeah.
Yes,
Here's the video on this should be out in about 3 minutes.
all right, do you have your witness?
Oh, that's not gonna be necessary.
Okay,
That's the very.
okay, all right, thank you.
Yeah, it's fine.
Retail. Yes. No, but when you're streaming this, I'm now. Yeah. it's a good idea. Yeah.
All right, the parties on Alfonso Diaz. Mr. Diaz, come down. Court is calling 2017 CR 9032, State of Texas versus Alfonso Christopher Diaz. Could I have parties announced for the record for the state? Defense,
Excuse me, Canton Longacre for Mr. Diaz.
are you Alfonso Christopher Diaz?
Yes, ma'am.
Showing you what's entitled motion to enter adjudication of guilt and revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, I did.
Are you the same Alfonso Christopher Diaz who was placed on deferred adjudication in 2017 CR 9032 for the offense of assault family second offense on September 26, 2017 for a period of 5 years? Is that you?
Yes.
State?
Your Honor, in violation of condition number 2, on or about the first day of June 2021 in Bexar County, Texas, the defendant Alfonso Christopher Diaz did then and there fail to submit to drug testing as directed by the court officer, supervision officer, and or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
True.
And Your Honor, we'll waive the remaining violations.
Any objections to the state's waivers?
No, Your Honor.
Mr. Diaz, did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 2?
Yes.
Court would find violation of condition number 2 true. Is there an agreement?
Your Honor, we do have a good recommendation to enter an adjudication of guilt and to sentence Mr. Diaz to 2 years in the Texas Department of Elections.
Is that the agreement?
Your Honor, that is the agreement.
Mr. Diaz, are you asking the court to follow that agreement?
Yes.
Are you waiving your right to appeal?
Yes.
All right, the court will follow your agreement. Yes.
Excuse me. Your Honor, we would ask that Mr. Diaz be credited for all the time he has served in this case, which is quite a bit. I think it's 271 days.
All right. So here's my question. What has he done on probation?
Judge, he hadn't done much. To the court, I'm sure he's an absconder. Mr. Diaz felt he has mental health. Serious mental health needs. Resulting from severe head injuries. He felt he wasn't able to get the treatment he needed for it here in Bexar County.
Well, I mean, not really, because counsel, I see that I've heard a previous motion to revoke for him. Now, mind you, this is from 2017. I know I wasn't on the bench on 2017, so I don't know what another judge did. But I know in this court, I always ask anybody, is there anything that they need that I haven't given them? Is there anything that probation is not doing that they feel that they haven't done? So if he didn't have mental health issues addressed, it's because he didn't ask for it. But we were here on April 28th for a violation of 5 and 15F. And I denied those motions, and I said he's enrolled in the BIPP within 10 days of release from custody. And he was allowed to work, and we were asking, and I put in GPS. So has he done anything since he's been on probation?
No, Your Honor, he did not complete the CIPP. I believe he started the outpatient program, however, he was discharged unsuccessfully. No, we have not received any UAs from him. There has not been any payments for any type of dues.
So he has done nothing. What have you done since you're on probation? Would you like to address the court?
Yes.
All right, I'm going to raise your right hand. The state is going to have a chance to question you. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Alfonso Diaz.
All right, what have you done?
I was constantly going, I did sign up for the BIP program, but they wouldn't let me go without a negative COVID test. I did test positive for COVID and did again the following month. And I did do all of the outpatient program, but I didn't submit a drug test. That's why I was discharged. No, as far as the ankle monitor, they wouldn't take it off of me because they wanted me to pay $200, but you waived the fees and they just wouldn't have it. Me and my probation officer were supposed to talk to you about that, and that never happened.
So basically you have done nothing. Like the easiest thing to do is take a UA. You did not do that. Did you ever take a UA?
No,
All right. So that's something that's easy to do. Am I wrong in that assumption?
you know,
All right. Did you complete the BIPP course?
no, I was never allowed in. I have a proof email. You got a letter for it, an email from the people who do it.
So you're telling me since 2022, you have never been COVID-free to do a COVID exam. And actually, there's a motion to revoke that was issued for you July 20th, 2020. And I granted a BF and issued a judge's warrant because you didn't show up. And I'm sorry, it's April 28, 2021. You're telling me that since April 28, 2021, you never tested negative for COVID to start the BIPP course. Is that what you're telling me?
Judge, I have to, I've never seen an MPR from 2021. The latest I've gotten is from 1920.
No, he didn't. Here it is right here. I think you were not the attorney at that time.
I believe you, Judge. I'm just
Yes.
saying, in my efforts to get all of the motions to adjudicate and revoke, up until this morning, the latest one I had was from 2018. After being assured I'd gotten everything. Finally, this morning, your clerk handed me one dated from 2020, said, sure, me that was the last one. I have not seen them. 2020, the one I have in front of me is the last one I've gotten, and I just got it
Do
today.
you want that, counsel? Do you want more time? Because there's one from February 25th, 2019. And on that motion to revoke, he was not revoked and he was told to do certain things. And from that, and then there's a violation report from 2017, which I didn't consider because I was not the judge at that time.
Judge, I'm not sure it's necessary that I see them. What I do want to disagree with, if I may, is
Mhm.
that your conclusion that he's done nothing, he wasn't able to complete the bit program because of the COVID problem.
All right, I hear what you're saying, counsel, but you just told me that he absconded.
I just told you that what I intended to tell you was he believed he couldn't get treatment he needed as a result of the serious head injury that he has here in Bexar County. I know that's likely inaccurate, but that's what he believed. Believing that, he elected to go to Massachusetts, where he did get help for that in a number of respects. He obtained a job, which he still has with Walmart for, I suppose it's a union Walmart, for $18 an hour as a stocker. He has gotten counseling up
All
there.
right, but we're in the middle of him testifying. So does anybody want to ask him some questions? Because before me, what I have right now is he's done nothing.
I'll ask some questions.
Sure.
Mr. Diaz, where have you been living while you've been not reporting?
For the last 3 months in Massachusetts and North Adams,
What brought you to Massachusetts?
to seek help because it's a Commonwealth state, and I was immediately getting help for mental, from my PTSD, and also I've been getting memory issues, so I decided to seek help for my for a neurologist.
So, but that was 3 months. So where were you before that time?
I was here, I was living in my apartment, I wasn't leaving. I had severe PTSD and severe anxiety, so I wasn't leaving home.
What caused your PTSD?
I was shot at when I was 14, and when I was arrested for the last MTR, I was arrested because I called the police. I was shot at again. And when I was 17 years old here in Bexar County, I was beat up while I was here before 17-year-olds were kept away from the general population.
Okay, have you had any contact with the victim in this case, Molly?
No, not so. No.
Do you have a new relationship?
She's the mother of my other 2 children, but it's purely civil.
And how old are your children?
My other 2, 12 and 11.
So you were in Bexar County. Did you have a phone?
No, I didn't. No.
Did you have a job?
I had lost my job due to me staying inside it too.
Due to what?
Due to me staying inside, it was agoraphobia. I was afraid of going outside for any reason at all.
So this is what I don't understand. One, these are some questions I have. The first one being, did he have permission to go to Massachusetts?
I don't see anything in the system, anything such.
So we have him going to another state without permission. 2, there's treatment for PTSD here. If it would have been asked for, I would have ordered it, and it's not here.
Yeah.
So that's a problem. So what I'm looking at is someone who has behaved as though they're not on probation. And now they're coming to me with excuses as to why I should give them a minimum. And he's had a motion to revoke in 2018. March 2nd, 2018, according to the docket sheet. Then he had another one in November 6th, 2018. And let's say that, I don't know, that judge was like, I'm not listening to you about what you need. I'm not saying that's true, but let's just assume that's true. He came back here July 20th, 2020. A warrant was issued for his arrest. Didn't see him back till April 28, 2021 to address the same allegations that were in the previous motions. And what did I do? I denied it, told him to roll and bip. And he's up here working at a grocery store at Walmart. Well, working at Walmart, I don't know if it's Super Walmart or not. Did you give them a COVID negative test?
No.
All right. So he is trying to tell me, and if this is not what you're telling me, let me know. It appears to me that you're trying to tell the court that you could not prepare or get a negative COVID test since April 28, 2021. And that's why you can't enroll in BIP. So are you telling me that you've had a positive COVID test since 2021?
No.
So he didn't do BIP. He hasn't reported. He left this, not just the county, he left the state without permission. And he's saying he has, PTSD and he can't leave his house, but he sure left his house to go to Massachusetts.
I also left my apartment because there was construction and we got locked in. They lifted the building while we were still in it, so I had no choice but to leave that apartment and I had nowhere else to live.
Yeah, but I mean, you left
I
with
don't-
all of your mental health issues that you're telling me that I don't have any documentation of. You left not only your apartment, but you left and went to an entire different state.
Yes.
And I'm not a psychologist or a psychiatrist, but I will tell you in undergrad, I took enough psychology courses where I could have majored in it, but I just chose not to because that wasn't a field I wanted to go in. So you're telling me you can't leave your house because of a mental health issue, but all of a sudden, not only do you leave your apartment, which I understand they closed it down, but you're able to get to another state. And how did you get to that other state? Did you take the bus? Did you take the plane?
Drive.
All right. So you drive to an entirely different state. And I'm sure from here to Massachusetts, there is no car that will take you there without stopping at a gas station to fill up. How many times did you stop at a gas station to fill up?
I'm not exactly too sure every 300 miles, but I'm not the one who was getting out.
All right. So you drove there with someone else?
Yes, my wife, my kid.
All right. So he's driving around with his children. So I can tell you right now, I'm not following this agreement because you have done nothing. And to receive the minimum for doing nothing would not be fair. It wouldn't be fair to you to teach you a lesson. It would not be justice. I understand that sometimes people have built a new life for themselves and they want to forget about the past and act as though that never existed, but it did exist. And you have done nothing. So I'm not giving him 2 years.
All right, Your Honor. Given that the case, I've already canceled the witness I was gonna testify this morning.
Oh, no, he's already pled true. I'm going to sentence you to 3 years in the prison. Give you credit for any time served. There's an affirmative finding of family violence.
Family's gonna be homeless.
And there's to be no harmful or injurious contact with Molly, Mollie Alvarez. All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
You did, Your Honor, under the impression that his sentence is going to be 2 years.
Well, no, because when I asked him, I said, do you understand by pleading true to violation of condition number 2, the court could sentence you up to 10 years in prison and up to a $10,000 fine? And he said, yes. So because this is not a plea bargain agreement, you do have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Because this is an affirmative finding of family violence, and also because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you.
Your Honor.
You're welcome. Carlos Salazar. And Ms. Ferguson, if you can call Mr. Porter to see where he is.
Morning.
Good morning. Where's Mr. Salazar? All right, what is happening with this case? Last time we were here, there were some discovery issues and the state was to make an offer today.
Right. Mr. Salazar and I are meeting in my office next Tuesday to review the video discovery, in particular his video statement. We have neglected to have that done, and that's my fault. I failed to contact Mr. Salazar to get that accomplished. I want to see if the court would allow us one setting so we can review the discovery and we can make a decision where we're going to go.
All right, has an offer been tendered?
Not yet, Judge. I can get one from Daniel.
All right, State, are you prepared to make an offer in the case with Mr. Salazar?
Yes, Judge.
All right, Ms. Ferguson, I need this reset for 30 days for a plea deadline date. All right, June 12th.
Thank you, Judge.
You're welcome.
Seat over here, yourself.
Doesn't work. You're always with the chair to make lemonade. Yeah.
Real wrong.
Hi, can I have the staff? Oh, yes, I'm sorry. Okay.
So.
Oh, okay, I'm not. Yes, okay, thank you. All right, court is calling 2023 CR 0223, State of Texas versus Melvin Hernandez. Can I have parties announced for the record for the state?
Jason Garrett, your
Defense.
Albert Chidas for Mr. Hernandez.
And are you Mr. Hernandez?
Your microphone is turned on.
Thank you. Are you Mr. Hernandez?
Yes.
Thank you very much. Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
I did, Your Honor, and I did.
All right, in probation, there's no application in this case. All right, Mr. Hernandez, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
No, Your Honor, the state is proceeding to the state jail felony, so we are waiving the enhancement paragraph.
Any objection?
No objection.
Mr. Hernandez, I'm showing you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes.
Did you understand you're charged with the offense of possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Hernandez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargaining agreement, punishment is to be assessed at 6 months in the state jail facility. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes.
State?
It is, Your Honor.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence?
Yes, Your Honor. State Exhibit number 1 with all of its attachments.
Any objections?
No objection, Your Honor.
All right, state, you may be excused.
Thank you.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, just that we just want credit for the time that he's been in county.
All right, Mr. Hernandez, it appears that you have a drug issue.
Yes, ma'am.
All right, how often have you been using?
Since I was 20. I'm
So-
33 right now.
All right, so what are you doing to help yourself with this drug problem?
I went to treatment twice, but I completed it, but it relapsed.
All right, do you have any does he have any violent criminal history?
I think so, Judge. It's mostly drugs related. This-
State, do you know if Mr. Hernandez has any violent criminal history?
He has a family violence case. Not a current one.
Not particularly, Judge. It looks like he got charged with adult bodily injury. Looks like a misdemeanor. But other than that, he has convictions for criminal trespass, failure to ID, possession, and possession of marijuana. Like that.
Okay. All right, Mr. Hernandez, I'm going to give you a choice. You can either take the 6 months in the state jail facility. What's going to end up happening, I'll give you credit for any time served. I will recommend you for the therapeutic community. I will tell you about the free drug treatment they have out in the free world. Or I can give you probation. And if I give you probation, you're going to remain in custody to go into an inpatient facility. Either way, for you, time is going to pass. It's just a matter of how it's going to pass. Is it going to pass for you when you're clean and sober, or is it going to pass for you addicted to drugs? Because at some point in time is going to run out for you. Either, as in this case, you're walking in the middle of the street where somebody could have hit you. Either you're going to end up in an accident where a car hits you, and then somebody is going to want to arrest the person who hit you. Then some witness is going to say, no, he was walking in the street. Nobody could see him. That person will feel bad that they've hit somebody and maybe killed them, but it's not going to be their fault. It's going to be yours. Or either you're going to end up with drugs that are not good. Maybe it's a bad batch. You're going to end up dying from that, or either you're going to end up overdosing, or either you're going to end up spending the majority of your life in and out of custody and in and out of prison. And at some point in time, you're going to get to the point where this state jail felony is going to be a habitual, and you're going to be looking at 20 years prison for what would have been a state jail felony, but for the fact that your punishment is going to be up to 20 years. So the choice is yours. If you want help for your drug treatment, I will place you on probation, but you're going to be going into inpatient treatment. Or if you want to continue on this road where you continue to use and come back, then that's completely up to you. Okay. All right. Don't ever go before another judge and say that you were not offered this. And I'm going to write on this docket sheet that I offered you treatment and you said no. You understand? All right, the court is finding you guilty. The court will sentence you to 6 months in the state jail facility, give you credit for any time served, showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it, and did you sign it?
Yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, because you waived your right to appeal, you do not have the court's permission to appeal. And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, good luck to you.
Thank you, Judge.
You're welcome. Ms. Ferguson, were you able to get in touch with Robert Porter? All right. See if, let me see. Oh, Mr. Charis, are you available? All right. No, just let him know we have. Is he available to come now? So you said, yes. Okay, thank you. So he's. All right, thank you.
So no, nothing. Okay.
All right, Mr. Cox and State. Mr. Porter is going to be here and you all need to tell him what the issues are with this witness, because he's going to represent this witness. So he's coming from the 226, so he'll be here shortly. And where's Nathan Spain? Does anyone know, is he on his way? All right, thank you. Anthony Backley. No, he's on the, he's for this case. Backley's license. I'm doing great. No, I need to start saying it's a lemonade kind of thing. Get lemons and you make lemonade.
Just do it all today. We'll see.
All right, who's here on Lindsay Pierce?
Lindsay Pierce and Brett Aguilar, the person that we would like to have contact with.
Yes.
And I am judge. May I bring them all up, or how do you want to do it?
Oh, just bring your client up first.
Okay,
Court is calling 2000, and counsel, you're on this side.
yes, ma'am.
Court is calling 2022 CR 5919, State of Texas versus Lindsay Pierce. Could I have parties announced for the record for the state?
Ruben Herrera.
Defense,
Andrew Del Cueto for Ms. Pierce.
and are you Ms. Pierce?
Yes, ma'am.
All right, defense has filed a motion to modify conditions of community supervision. State, have you had a chance to review this document?
We have your honor.
And probation,
Yes, Your Honor.
are you aware of this motion to modify conditions of community supervision?
Yes, Your Honor.
State, are you prepared to proceed?
We are.
All right, state, do you have any objections to the motion?
We do not understand, Your Honor.
All right, and defense, there is a witness that the court wanted present.
Yes, Judge.
All right, if you can call that witness.
Yes, Your Honor.
It's red. There you go. Thank you. I'm telling you, it's one of those days. All right, I'm sorry, what is his name?
Mr. Aguilar, Brent Aguilar, Your Honor.
All right. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, and if you'll state your name for the record, please.
Brett Aguilar.
All right, so the court is in receipt of a motion to modify conditions of community supervision. And they are asking, the defense is asking that the no contact order be changed. Are you aware of that?
Yes, ma'am.
All right. Do you have any objections to this no contact order being modified to no harmful or injurious contact?
No.
All right. Do you have any fear of the defendant? Any questions?
No, Your Honor.
State, any questions?
Oh, yeah.
All right. Thank you so much for coming in. I appreciate it.
Yes, ma'am. Thank you.
You're welcome. All right. All right, the court will grant the motion. Is there anything else from either side? All right, so probation in this case, the conditions are changed to no harmful or injurious contact with Brett Aguilar. All right, probation will give you new conditions to sign and then your excuse.
Thank you.
All right, thank
Have a
you.
great day, Judge.
You too.
Go across. Zero.
All right, who's here on Arnold Garza?
Thanks for reminding.
All right, court is calling 2022 CR 7734, State of Texas versus Arnold Garza. Can I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Leslie Sahanovich.
Are you Arnold Garza?
Yes, ma'am, Mr. Am.
Counsel, have you received all the discovery and did you review it with your client?
We did, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Garza, I'm showing you what's entitled Application for Community Supervision. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, ma'am, I sure did.
Next, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
No, Your Honor, the state is waiving the repeater status.
Any objection?
No objection, Your Honor.
All right, Mr. Garza, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Waivers of Affidavit and Admonitions. Did you review that with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am, I sure did.
Did you understand you're charged with the offense of possession of a controlled substance, penalty group 1 gram to 4 grams? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am, I sure did.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Garza, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am, not at all.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
I sure am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am, I sure did.
According to the plea bargain agreement, punishments be assessed at 6 years in the prison. There's a $1,500 fine. State recommends community supervision. No applications for deferred. State will take in consideration NIMAC number 70774041 and 42. And there's to be restitution to SAPD for laboratory testing. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes.
State?
That is, Your Honor.
Showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Sure did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No.
Showing you outside the plea bargain agreement, the state is requesting that your community supervision be for a term of 6 years. There'll be a top evaluation, 200 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest, ma'am.
State any evidence?
Yes, state exhibit number 1 with all the attachments. Your
Any
Honor.
objections?
No objection.
All right, state, you may be excused.
Thank you.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am, I sure did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, we are, Judge. We wait PSI.
All right, anything you wish to say on behalf of your client?
I know you're on.
All right, Mr. Garza, do you have any children?
Yes, ma'am, I sure do.
What are their ages?
27, 22, and 17.
All right, 17-year-old living with you or someone else?
Someone else.
Are you employed?
No, ma'am, not at all.
So how are you supporting yourself?
I've been here, I've been slacking lately, you know what I'm saying? But
I didn't understand what you said. You've
I
been,
just been doing nothing really lately, you know what I'm saying? But that's why I'm on probation, get on track, man.
no, my question is, how are you supporting yourself?
I don't support, I'm on the streets, I was on the streets. So living off of, you know what I'm saying, uncles and aunts and cousins like that, helping me out.
All right, and how old are you?
I'll be 40 this year.
You need to get a job.
Yes, ma'am.
And what's up with all of these tattoos?
They're just form of expression.
All right, off the record for a moment. Mr. Cox, have you spoken with Mr. Porter? All right, state.
There it is.
All right, Jason, could you have the state speak with Mr. Porter and Mr. Cox? Mr. Porter, you're going to be representing a witness. And Mr. Porter, the witness is by Zoom, so I'll of course allow you to zoom in. Deputy Laura, if you could give him the Zoom link. All right, we're back on the record.
Yes, ma'am.
So what's up with all of these
It's a
tattoos?
form of expression. My neighborhood and stuff like that.
Well, no, usually when people tattoo their neighborhood, there's something else going on. So what do your tattoos say?
It's a 5P. I'm from Five Palms. Indian Creek.
Oh, yeah, we're going to do a gang evaluation.
Yes, ma'am.
I mean, you know,
Yes, ma'am. Yes, ma'am.
and one should be done, right?
Yeah, it's understandable.
I'm sorry, what?
It's understandable. I have no problem with it.
All right, and so what gang is going to pop up?
There's no gang. You can check my record. I'm a trustee right now. I've been solo the whole time.
All right, so this is what the court is going to do. The court is going to sentence you to 6 years in prison, suspended and probated for 6 years. There's a $1,500 fine that will be probated. The court will take in consideration the following NIMAG number 70774041442. There's going to be proof of employment within 15 days of release. There's to be no employment as a home health care provider or with minors. There's to be regular UAs, gang evaluation. I'm going to want field visits 1 time per month until he's on gang supervision. There's going to be regular reporting by Zoom or in person. How far did you go in school?
I got my GED, but I went to 11th grade.
All right, so what are you planning on doing with your life?
Getting a job and starting work.
All right, there's going to be 200 hours of community service restitution. And I'm going to want a TAP evaluation and probation. That TAP evaluation can be done out of custody. If you do not make your TAP appointment,
yes, ma'am,
what's going to end up happening is a warrant's going to be issued for your arrest and you're looking at 6 years in the prison. Do you understand?
Understandable, yes, ma'am.
All right. So the lightning bolts or the cracks in your head, what are they?
Hard-headed. It needs to be hard-headed. It's for the cracks.
Oh, so that means hard-headed? Yeah. And what's the name on the cheek over here?
My mom's name.
Yep. You know what, Deputy Laura, I always tell people, moms don't appreciate you tattooing their names on their body, but if there is anything that's a safe bet, any name to tattoo on the body, it's the mother of the children. Everybody else shouldn't be doing that. All right, probation, is there anything else he needs? Is there anything else you need from the court to be successful?
Just to be on my bottom.
Be on your what?
Be on my, I don't want to say it, but just to be on my bottom, like to be on my
Word.
Yeah.
Okay. All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? Did you sign it? Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Who is that in the doorway? If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Oh, yes, ma'am.
All right, good luck to you.
Thank you so very much. You have a
All
good
right.
day.
All right. And I will tell you, the key to successful probation in this court is communication.
Yes, ma'am.
If there is something that you need, ask it for it from probation. If you feel they're not giving it, you can always come to the court and ask me, okay?
Understandable. Yes, ma'am. Thank you. very
All right,
much.
good luck to you.
Thank you. Have a good day.
You too.
What's our?
Yes. Hello. Okay.
Let me get out of the way in case.
Okay, sure. Thank you.
Melvin Owens.
Okay. All right, so you're asking for the investigator to be paid in excess of the amount issued, is that correct?
Yes, Your Honor. I have a brief presentation for that.
Okay.
Very brief.
All right, so this is what I recommend to make this move faster, because we have to send it off to the voucher committee.
I understand.
All right, so if you want to write a letter or something that can go to the voucher committee,
Okay.
I'm sure it's not going to be any problem, but this is the process we have to go in. And what I can do is I can have Ms. Ferguson contact them and let them know to do this as quickly as possible.
Thank you.
All right,
This has been a long going case and several attorneys.
okay,
He's in and out of competency, so there's some issues here.
okay. So that's what we'll do. And Ms. Ferguson, when is Melvin Owen set? Oh, he's still incompetent?
Your Honor, I read through all the files yesterday, and it seems like there was a restoration hearing when I was not available, and so
Okay.
I have to check with the impact court on that. Because the record shows he's incompetent, but I think there was a restoration hearing recently that.
All right, Ms. Ferguson, if you can check on that. And then if you'll send this request for payment to the investigator to the voucher committee.
And I'll bring in the letter. Is that acceptable?
Oh, yes, just make sure it gets to the voucher committee
Gotcha.
and we can upload it in the system and send it to them.
Thank you very much, Your Honor.
Oh, you're welcome. The only reason why I can't sign it is because it appears there wasn't an order requesting it and it went above that, but I honestly don't think there'll be an issue.
Okay, thank you, Your Honor. I'll get that letter overnight.
Okay, thank you.
Thank you.
Do we have a date?
Did you want a 30 or 45 days?
No, I mean, is there a date in the system?
Oh. One second, I'm still. There's no date in the system, but I'm trying to see. Yep, there's nothing in there.
All right, and are these family violence or criminal trial division?
Oh, family violence.
All right, so family violence on Melvin Owens, because he is going in and out of competency. Ms. Ferguson, do a phantom date for this and set it for the 30th.
30th of this month.
Yes.
And remember what was the defendant's last name?
Owens. All right, so you all had a chance to speak with Mr. Porter?
Mr. Porter wants.
Oh, yes, just when he zooms in, then I'll put him in a breakout room.
Have excuse, John.
Yes, thank you so much. And is he still talking to Mr. Cox?
No.
Okay, can you have Mr. Cox come in, please? Thank you. All right, Mr. Slemay. Can I see you, Mr. Cox, and stay in the hallway briefly, please? All right, so this is an update. For those of you who are here for jury trial, I'm going to actually have you all come back at 1:30 because we're going to finish this bench trial. My understanding is this bench trial is going to be completed by 12, and then the court is going to take its lunch break at 12. So I say that we're going to be up here at 1:30. So if everyone who has a trial that's scheduled, if you can make sure you're in the courtroom by 1:15 with your client and bring your client into the courtroom because jurors are going to be in the hallway. Okay? Hi.
So you asked him to come back at 11. I just want to make sure
Yes.
he's clear to come back
Back
at
at
1:30, so I can
yes.
catch him now. So
Well, make him come back at 1:15.
1:15.
Yes.
Thank you.
All right,
Okay.
thank you. And I assume you and Miss Cupid will be trying this together?
If we're going, yes.
Okay, all right, awesome.
Okay, thank you.
You're welcome. Okay. All right, thank you. And just, yes, tell them to come back. You know what, actually, tell the jury to come back at 1:45 because I know some of the attorneys are gonna be like. Okay, all right, thank you. Because I found that we will lose jurors if we call them back. It will be extra late. We learned that trial and error. 1:45 for the jurors. Oh, you're fine. You know, when you give people that Zoom link by number and just tell them to put for some reason, it never works. I don't know why. Sure. Do you need the case number? Mr. Leal, you'll need to be back here at 1:15.
Yes, ma'am.
All right, thank you.
You could inform me.
Okay. Thank you. Hey, no, I appreciate that. You know, we did that in school once and then, but you were supposed to be going on a camping trip and everybody would say one thing. And then when it got to the last student, it was something completely different. Yeah. You did excellent. And for family violence, for the cases that are coming back, can you make sure that an acknowledgement of discovery has been completed?
I'll let them know.
All right, thank you.
They got it. All the cases coming back.
Jason, thank you.
We need a translator.
Yeah.
As far as we're aware.
Okay, nobody has, is there, let me do an invitation because I don't know why it's
Support.
taking them forever to log in.
Sorry.
Sure, working. I gave him a due and a closed offer.
See, here's the thing.
Yeah.
Oh, Jason. Robert Porter still has to speak to his client.
Okay.
So
We
we
still
can
have.
still continue. You have time.
Thanks.
You gonna do that? Wait, just wait. Kind of well. 1 second on the lesson. Is there 2 counts? Yeah.
Helps you.
It's a first sentence. There.
Okay.
This week, she said 11:30.
All right, I'm going to put you in a breakout room and your attorney is going to meet you in the breakout room. Ms. Younger, I'm going to send you to a breakout room and your attorney is going to meet you in the breakout room.
Okay.
And I'll send you the breakout room number 2.
Okay, thank you.
You're welcome.
What?
As far as I can tell, nothing. Like he
Is
doesn't.
he convicted felon in that drug case?
Um,
Here. For convicted.
Yeah, it's been for 4-year probation.
You know what I'm saying? Like, I'm not here to attack him.
Right.
Unless.
This one? Can you hear me okay?
All right, Mr. Slimane, I'm going to send you to a breakout room with your client. She's in breakout room number 2.
Got it, Judge.
Thank you.
Thank you, Judge.
Are you okay? Oh, is he ready? What's in the middle name? Okay. All right, thank you. DUIANT. All right. Court is calling 2019 CR 4004B, State of Texas versus Santuan Wilson. Are both parties ready to proceed? State? Defense?
We're ready, Judge.
State, are you ready to proceed?
State's ready, Judge.
All right, defense, call your next witness.
Okay. Your Honor, we're gonna call Anthony Bagley.
All right, Mr. Bagley, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand. Before we begin, Mr. Bagley, an attorney was appointed to represent you as a witness in this case, Mr. Robert Porter. Have you had sufficient time to speak with him?
Yes.
All right, Mr. Porter, have you had a sufficient amount of time to speak with Mr. Bagley?
I have, Your Honor.
And were you able also, Mr. Porter, to speak to attorneys for the state in defense?
I did.
All right, Mr. Bagley, if you could state your name and spell it for the record, please.
My name is Anthony Bagley, ANTHONY BAGLEY.
All right, defense.
Thank you, Judge. Okay. Mr. Bagley, do you presently live in San Antonio?
Yes.
Okay. And how long have you lived in San Antonio?
My whole life.
Okay. Now, you do you recall being served with a subpoena on yesterday?
Yes.
Okay. And approximately what time were you served that subpoena? More or less.
I want to say around maybe in between 3 and 7 p.m.
Okay. Now, are you familiar with a Brianna Younger?
Yes.
Okay. And if there is a relationship, what is your relationship with her?
She's the mother to my 2 daughters.
Okay. And do you all share parental responsibilities in terms of keeping the children, those types of things?
Yes. It hasn't always been how can I put it, ideal, an ideal situation, but recently it has gotten more structure to it.
Okay. Now, do you and with reference, Ms. Younger, do you see her reference the kids on a daily basis, or do you on a weekly basis, or anything like that?
Objection to relevance, Judge.
Well,
Mr. Cox, how is this relevant?
well, Judge, I want to get into any conversations that were had about this case.
Oh, then you can ask those questions.
Okay, that's fine. When did, sir, in the last week, have you either spoken to her or she spoken to you with reference anything surrounding this case that you were subpoenaed for?
What she did tell me earlier this week, or I should say last week, when she dropped the kids off, is that she had.
Well, Judge, it doesn't go to matter. The truth of the matter asserted. I want to know in reference to rule, whether there was any violation of it, and the state knows exactly where I'm coming from, Judge. I just want to know whether there was any conversation.
That objection will be overruled.
Okay. So you said there was some conversation about this case, correct?
No. What I was going to say is that there was when she was dropping the kids off, she told me that she had something that she had to do. And I told her, because I've been looking for a job and everything, that I can't watch the kids for like this amount of time because it goes against our usual, what we have basically established over the past like 2 months. And she was just telling me, I'm going to need to figure it out because she has something important she has to do. And, it kind of almost turned into an argument, but,
okay.
I definitely was able to do what I had to do on my part.
Okay. Was anything said about this case?
No, I didn't know anything about her having to go to court or anything until I got the subpoena, and I called her. And when I called her, I was like, okay, is there like an attorney I can speak to? Because I don't have an attorney. I just got one, and she told me that I wasn't allowed to talk to her attorney, and I have to go in there and tell the truth. And I wasn't able to get any information really about the situation until basically like today when I spoke to you.
Okay, so the only thing that you talked to her about yesterday was that you had gotten subpoena, and once you got the subpoena, you called her, correct?
Yeah.
Or you called her, or did y'all meet?
She came to pick up the girls afterwards because the main reason why I called her is because she's gonna have to pick up the girls because I have to go to court. Well, I was under the impression that I had to go to court.
Okay, so the conversation you had about coming to court, was that during the time you talked on the phone, or was it when she came to you?
Objection to relevance.
I just want to.
All right, that'll be overruled.
And asked and answered, Judge.
All right, that'll be overruled.
When was that conversation you're talking about you coming to court or testifying? Was that a situation that happened on the phone, in person, or at both times?
In all honesty, I'm trying to recall, but it's I want to give you an accurate answer. I want to say it was over the phone. But in all honesty, like I'm pretty sure it was over the phone, because when she did pull up, I put the kids in the car, and there wasn't really, we're not really on the best of terms, so it's not just a thing where we're gonna just be in each other's face, like talking about our day and stuff like that. But I believe it was over the phone while I was telling her, okay, yeah, you gotta pick up the kids for sure.
All right, now what I want to do is take you back to June of 2018. June of 2018. Were you all living together at that point during that time period? June 2018.
I'm gonna be honest with you, sir. That was so long ago. I really can't remember. I know we weren't living together, but I don't want to give you an answer to a question and I'm not 100% sure. You know what I'm saying?
Did you all ever at any point live together? And if so, what time period are we talking?
I wouldn't even necessarily call it living together, but there was a time, as I'm sure the court is aware, where I caught my own case involving marijuana, possession of marijuana, and I was into it with my family, because of the situation, and she let me stay with her for about a month or two, but our relationship just it wasn't ideal.
Okay. Do you know whether that was in 2018?
No, I couldn't tell you. I know. I feel like it was earlier. It was earlier than that.
You feel like it was earlier?
I'm pretty sure it was earlier.
Okay. Now, did you, if you didn't live with her, did it for the time that you would stay a couple of nights or anything like that back in 2018?
There was times where I would, spend the night in the morning, like, cause she has to work at night, and she would ask me, to come and, watch the kids for her and everything. And, I'd do that. And then, when she'd get home, I'd go ahead and go back home.
Okay. Now, are you able to see the person that's seated to my left?
Yes.
Okay. Okay. Mr. Wilson, Santon Wilson, have you ever seen him before other than today?
I remember seeing him at a let me see, what was it? HEB before.
Okay. Had you ever seen him at Brianna Younger's house?
No.
You never, there was never a situation where you were, there was knock on the door and you were called out to talk to him or have a conversation with him on the porch, front of the house?
Yeah, no, not at all.
Do you know a Gary Clark?
Yes, I know Gary Clark.
Okay. Back in June of 2018, do you recall ever having any type of argument with Gary Clark?
That was a long time ago, sir. I'm gonna be completely honest with you. I do remember us getting into it, and I remember talking to his girl, his child's mom, and I'm not sure if it had something to do with her or not.
When you say her, who are you talking about?
His child's mom.
Oh,
I'm not
his
sure
child.
what. Yeah, I'm not sure what her. It's been so long. I haven't heard anything from Gary or in all honesty, in a long time.
All right, so you don't remember anything about a incident that happened at Gary's mother's house that you may have been involved in?
No, I don't.
Okay.
In all honesty, I don't know if it's on file, but I actually went to a drug rehabilitation program. I was addicted to drugs, for a while, and my memory is very, very hazy on, a lot of things that happened in my past.
Okay. So you're not testifying that it didn't happen. You testifying that.
I mean,
you remember it's hazy and it could have.
All right, so just 1 second, I'm sorry. So you all have to remember that the court reporter is taking everything down.
Yes,
and I know sometimes we speak conversationally, but remember, one person speak at a time.
Yes, ma'am.
Mr. Cox, you can ask your question.
Thank you. So, sir, are you saying that your memory may not be reliable because you were could have been under the influence of drugs during those periods of time?
Objection to leading, Judge.
All right, that'll be overruled. You can answer the question.
Can you ask the question again?
Okay. Are you testifying that back June 28, 2018, you could have possibly be under the influence of drugs, and that's why you don't remember things specifically? Is that?
No. What I'm saying is my memory is very, very hazy. But like I said, me and Gary, we were pretty close at a point in time. So I'm pretty sure I would remember if something like that happened.
Okay. Do you remember if with Gary having a argument about either the sale of marijuana or the delivery of marijuana?
No, I don't.
So you know specifically that never happened. So you're saying that never happened?
I'm saying no, I don't remember that. No.
So you don't remember whether it happened?
I'm pretty sure it didn't. Like, I don't understand how that would happen.
were you ever made aware, and I'm talking back in 2018, that that any type of allegations or stories that information that Brianna may have been, or her house may have been robbed or anything like that?
So one thing that I do remember vaguely is something happened one day. I remember being over at the house. I left because I guess she had got home or whatever. And she calls me like hours later saying that, you know, something had happened at the house and, you know, basically not to worry about it because she called the cops and other stuff. And I you know, I didn't, like I said, we didn't have the best relationship. So it's not a thing where I'm just like, you know, and she didn't really go into great detail. So.
Okay, so you do remember a call.
Yeah.
That was made to you. And right, and that call, it's fair to say that was back in June of 2018 when that call was made to you about something happened.
One thing I will say is I can't give you a time frame because that was like years ago. You know, I don't know if it was that time, if it was another time or what, but I do remember, you know, her telling me about something, you know, that had happened similar to, I guess, what this is about. I don't know, you know, I don't know who it pertained to. I don't know, you know, what the fine details were, but I do remember her calling me frantically at a point in time.
And just a couple more questions. So your testimony is that with reference to any argument that you may have had with Gary, you never went to any place, Mustang Valley or any place like that where an argument happened between you and Gary. Is that your testimony?
There is no time that I can remember me ever having an argument with Gary like that, especially like, you know, like I said, me and Gary used to be friends, but if we did get into it, it was probably an over the phone kind of thing. And it like I don't see, in all honesty, I don't see how that could be relevant in what we're talking about. Because like I said, me and Gary used to be friends. The only thing I could see us arguing about is like maybe a female or something, to be honest. Like if I'm being just completely transparent.
Okay. I'll pass with you.
State.
Mr. Bagley, my name's Lindsay Shaw. I'm the prosecutor on the case. I just want to ask you a couple questions, okay?
Yes, ma'am.
So on June 23rd of 2018, when Santuan Wilson and Derek Alexander robbed Brianna Younger at her house, you weren't there, were you?
No.
Okay. It's possible that you had been there earlier in the day, right? That's what you said.
Yes.
But when this happened around 8 p.m. on that day, you weren't present.
No, I wasn't.
You didn't see them at the house.
No, I didn't.
But in fact, you said that she called you at some point around that time. You're hazy on exactly when, but you remember at some point she called you and she was frantic. That's what you said, right?
Yes.
And she told you that.
I'm sorry.
And she told you she was frantic on the phone and she said, I called the police.
Yes, she did.
Did you ever go to the house after that when she called the police?
No, I didn't. She told me that, you know, she had called the police and not to worry about it.
So you and Brianna since 2018, or let's go back to in 2018, did y'all have much a relationship besides sharing your children?
No. And if I'm gonna be if I'm gonna be completely transparent, it was a thing where you know, we would definitely link for the kids. We'd meet up for the kids and everything. And, you know, I'd watch them sometimes. And then, you know, if we spent, you know, too much time together, it would lead into an argument, which was just like, so it was just never a thing where we could like really, I guess you get, I guess be together, you know?
Okay, so it would be normal then. It was normal for y'all to not really talk much about what's going on in your personal life.
Yeah, she lived her own like separate life. You know, her work life was separate from what I knew about her. Just I don't know. It was just kind of like a thing where, and that was one of our problems. It's like we just both lived lives separate from each other and we can never meet at that middle ground. So it just was never that I guess true comfort or trust. Well, that's just I'm pretty sure that's irrelevant. That's just relationship stuff.
Okay.
But, yeah.
And so how is it that you knew, that you know or knew Santuan or Keontae Wilson?
I don't know who Keontae Wilson is. Who is that?
Okay. So you don't even know a Keontae Wilson?
No, I don't know who that is. And
So you have no reason today, at this point, you're not even sure who that is. You have absolutely no reason to be in here testifying today and not telling the truth, right?
that's why I was shocked when I got this knock at the door saying I needed to come to court.
Are you aware that the co-defendant in this case, Derek Alexander, already
Objection.
pled to this case?
Objection to relevance.
Sustained.
Witness the co-defendant.
You don't answer that question.
Okay.
No further questions, Judge.
All right, any other questions?
Just a few more.
Okay.
Sir, when I asked you about an incident that happened back on June the 23rd, 2018, on direct examination, your memory was fogged up and you said that you probably on drugs during the time and you didn't remember, correct?
Yes, marijuana.
Right. All right. Now, as soon as the prosecutor asked you a question about this alleged robbery, then you remembered right away what we're talking about.
So what I had.
No, you got to answer my question. Did you remember right away?
No, I mean, we've been talking about it. You know, I'm not saying that I remember. The only thing, like I told you, sir, the only thing that I remember is there was a time period years back where I received a call and she was frantic. I don't, like I said, I don't know the intricacies of what's going on and things like that. I don't know that.
Okay, and that's fair. But when the prosecutor asked you that it was referenced some type of robbery, you said yes, correct?
I mean,
you just said it a few minutes ago, correct?
Sir, we've been talking about the same thing, right? This whole time.
Well,
so when she said that, I'm just basically referencing on what you have been telling me. I don't know the fine details of everything, but if I'm gonna just make assumptions, you know, taking what I've been being told, you know, from you with your questions and everything, then I'm gonna assume that's the same thing she's talking about, correct?
So you're just assuming based on whoever asking the questions, you're assuming that or agreeing to what we're saying without an independent recollection of it.
I'm telling you what I know, and I'm getting information from what the questions that you're asking me, and I'm answering them to the best of my ability.
Okay,
that's all
so
I'm doing.
When the prosecutor asks a question about a robbery that had happened, and you told her yes, were you assuming, or were you testifying based on something that you knew?
I was assuming off of the questions that you had just asked me that that's what she was talking about.
When she asked you the question about whether you received a phone call and that Was she hysterical? Was that
Frantic.
something that you were assuming? Or were you testifying based on something that you knew?
Like I said, sir, I remember there being a time because I mean,
No,
that's
my question to you was, were you assuming or were you testifying based on something that you knew?
I testified knowing that there was a point in time years ago where she had called me and she was very, frantic because of course that stood out to me.
Okay,
Did I
so
go into detail? No, I did not.
I'm sorry.
Did I have her go into detail about the situation? No, I did not, like I told you before. So it's like I've been telling you, I don't know the fine details of what's going on. I am taking I'm taking what I'm being told right now, and I'm trying to answer these questions to the best of my ability.
Okay, and you testified in reference to Santuan Wilson that you had never met him before. You may have seen him at a HEB, you said.
I said I remember, and I didn't even know I don't know him as Santuan. That's if that's who you were referring to a second ago, then yes, I do know him. I know him by a different name, and I only know him because I know Gary, and I remember seeing him at an some shopping center one time.
Okay, the person that's sitting to my left, you only saw him once, and that was at a shopping center, you think?
Yes.
Okay. I'll pass witness.
No further questions, Judge.
All right, is this witness excused or subject to recall?
Subject to recall, Judge.
All right, Mr. Bagley, can you wait in the breakout room? Because I believe there may be one more witness and then we'll bring you back. So I'll send you to breakout room number 3. Mr. Porter, if you could remain in breakout room number 3. Defense, call your next witness.
We're going to recall Ms. Younger.
All right, Mr. Salamane, I think your client may be having trouble coming back to the main session. And Mr. Bagley, there should have been something that popped up for you to go to breakout room number 3. If you'll go to 3, please.
Oh, yes, ma'am. Let me see. Okay.
And Mr. Salamane, if you can call your client and talk her out of that breakout room.
Sure thing, Judge. I'll do it right now.
And if it's easier for her to just sign out and sign back in, she can do that.
Okay, Judge.
Okay.
Okay, there she is. All right, Ms. Younger.
Yes, ma'am.
You are still under oath. The defense has some questions for you. Defense?
Okay, well, thank you, Judge. Good morning, ma'am. Just a few more questions. With reference, since we started this trial on, I think it was Wednesday, have you ever spoken to Anthony Bagley about this case?
Not directly about the case. I did speak to him about him having to watch our kids so that I could attend the court proceedings.
Okay. And when was the last time you spoke to him about the court proceedings or anything reference this case?
I saw him yesterday when I picked up my kids, and we were just trying to figure out, if I had to go back, would he be able to watch watch our kids, just the dynamic in which we were gonna be able to like have each other watch the kids.
Okay, did this case come up in terms of anything about testifying or anything like that whatsoever?
No, sir. All I know was that he just said he received his subpoena. He had to be there at 9 a.m.
Okay, so this was a conversation that you had with him in person, or was it a conversation that you had with him on the telephone?
In person when I went to pick up my kid.
Okay, did you ever have a conversation with him about subpoena or about testifying in court on the telephone?
No, sir.
And just a couple more follow-up questions, ma'am. There was a body cam video in this case. Were you ever shown those body cam videos by the prosecution before you testified?
Did you hear the question?
Oh, I said yes, sir. I'm not sure if you heard me.
Oh, you were shown the body cam videos?
Yes, sir.
Okay. And do you recall whether you're showing the videos more than once, or you just showed them one time?
I saw them multiple times. I don't remember the exact number, but I have seen them multiple times.
All right. Do you recall on your direct examination with me, excuse me, me asking you whether you had more than one purse? Remember me asking that question?
Yes, sir.
Okay. And do you remember your response when I asked you whether you had one purse or not in your closet?
I don't remember. I just remember that I had one person use.
Okay. When you say you only had the one purse, correct?
Yes, sir.
Okay. Do you recall on a video whether you demonstrated to the police officer how the person that went into your purse actually went into your purse? Do you remember that? Did you show one? Do you recall that?
Yes, sir.
Okay. Do you recall whether there was, and these purses were hanging on the back door of a closet, correct?
Yes.
Closet,
On a
correct?
rack.
All right, on the rack. Do you recall that it was more than one purse? When you looked at the video, do you remember it being more than one purse that was hanging on the closet?
Not that I remember, sir.
Okay, so your testimony still is that you only had one purse, correct?
I said I was using one purse.
So you didn't say you only had one purse.
I may have said that, but that the intention was that I had one purse that I had in use.
Okay, I'll pass this.
State.
No questions, Judge.
All right, is this witness excused?
Just for recall, Judge, we just went on.
All right, defense, call your next witness.
Okay, we can call the defendant, Ms. Wilson.
All right, Mr. Wilson, if you'll take the witness stand. And Mr. Slimane, I'm going to put you in your attorney in breakout room number 4. Yes, please. All right, and Ms. Younger, if you'll go to the breakout room that I requested, which is number 4.
Yes, ma'am. Thank you.
You're welcome.
Why don't you?
All right, Mr. Wilson, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, can you lower your hand? Please make sure you keep your voice up so that the court reporter can hear and the attorneys can hear. All right, if you spell your name for the record, please.
Santuan Wilson, SanTuanWilson.
Defense.
Mark, thank you, Judge. Okay, Ms. Wilson, you're the same, Mr. Wilson has been in this trial since we started, correct?
Yes, sir.
Okay. What I want to do, excuse me, I want to take it back to June 23rd, 2018. Did you, were you living in San Antonio during that time?
Yes, sir, I was.
Okay. And do you know Brianna Younger?
Yes, sir, that's my cousin.
Okay. And did you go to her house that day?
Yes, sir, I did.
Okay, you went to her house. Now, and you went to her house, were you by yourself or were you with someone else?
I was with Derek Alexander.
I'm sorry?
I was with Derek Alexander.
Okay. And excuse me. There was a particular reason that you went to her house, correct?
Yes, sir.
Okay. And what was the purpose to going over to her house?
Well, about like I would say between like between 3 and 5 that day, my little brother called me on the phone and he was saying that there was some guys outside my mama's door, and I could hear him beating on the door as we on the phone. So I told him make sure the door locked and I'm on the way. And I went to went to my mama's house.
Okay, you went to your mom's house. Mm-hmm. When you got to your mom's house, what was the situation? Were those guys still there?
No, sir, they wasn't. And my brother, he came. He said that his friend Anthony, he had owed Anthony some weed, some money for some weed, and he wanted to come over there and like basically shoot him up for not paying for the weed.
Okay. And the person, Anthony, do you know his last name?
Bagley, I believe.
Okay. Now, once that occurred, what, if anything, did you do?
Well, that's family. So I was like, well, I'll go talk to him and see what's the problem and why he came. Because my brother was saying that he paid him already. So I didn't understand why Anthony still went over there to, I guess, threaten him or whatever. So I went to go talk to Anthony.
Okay. So when you went to talk to Anthony, did you go by yourself?
No, sir.
Okay. And you went with who?
With Derek.
Okay. Now, when you went over there, were you armed?
No, sir.
Okay. Okay. And you went to the house, you get to the house, and what happened at that point?
Well, excuse me. I knock on the door. Brianna, my cousin, answered the door. I asked for Anthony. She told me to hold on and went to go get Anthony. Anthony came to the door. I asked him if he could step outside to talk about the situation with him and my brother. And we talked about it.
Now, when you say Anthony, the same Anthony that just testified here in this courtroom on Zoom?
Yes, sir.
Okay. And what did you talk to Anthony about?
Just basically see what happened while he went over there, even if he even went over there. he admitted that he did go over there, and I was basically I was just like, how can my brother be sure that he's safe? Like, how can we squash the whole situation? How can we drop the whole situation? He was saying that they got into an argument and it got heated, and that's why he went over there.
Okay. Now, were you able to resolve that situation with Anthony?
Yes, sir. Yes, we was.
How was that situation resolved?
He ended up, I asked him how we was gonna resolve the situation, and he went inside and gave me some weed.
Okay, you say he, you talking about Anthony?
Anthony went inside and gave me some weed, yes, sir.
He went into the house
Yes, sir.
and then he returned. How long was he in the house?
Like not even 2 minutes.
Okay,
Real
then he
quick.
comes back outside
Yes, sir.
and at that point he gave you some weed, marijuana.
Yes, yes, sir.
Okay. Did anything happen after that?
After he gave me the marijuana, my cousin came outside. Like,
You say your cousin, who you're talking about?
Brianna Younger.
Okay, and what happened there?
And she started yelling at me, like, give it back to him. I'm like, for what? And she was like, no, you know what? Don't worry about it. I got something for you. And I thought she meant like she was gonna get some guys to jump me or something like that. I didn't think it was gonna be to this extent.
When you say to this extent, what do you mean?
Making up saying that I robbed her. Because I didn't step inside her house, not one once.
So your testimony is that you didn't step into her house.
Not 1 foot.
Had you ever, before that day, have you ever been to her house?
No, sir.
Okay. And your testimony is that you didn't go into her house at all.
Not at all.
And have you ever been
inside? I couldn't hear you.
Inside, have you ever been inside her that house that we're?
No, sir.
Okay. And you said that you didn't have a firearm with you.
No, sir.
You never threatened anybody.
No, sir.
With a firearm.
No, sir.
The person, I believe you said his name was Derek, that was with you.
Mm-hmm.
Okay. Did Derek go into that?
No, sir.
Okay. So you all remained on the porch.
Yes, sir.
And neither one of you ever went into her house.
No, nobody went into her house, sir.
I'll pass with it.
Mr. Wilson, I have a couple questions for you.
Yes,
Okay.
ma'am.
So then let's talk about what we all agree with, what you're saying is true. So you're telling this court that it is true that you and Derek Alexander went to Brianna's house June 23rd, 2018, right?
Yes, sir, ma'am.
Who was the third person that went with you?
Do I have to ask that question?
Yes.
My brother Gary.
Gary went with you. Who drove?
That's who was drove. It was only 3 of us.
Okay. How'd you leave then?
Because I got in the car.
Who drove the car?
Gary.
Okay. And so you and Gary and Derek went to Brianna's house. Were you invited over there?
No, that was family. So, that's how we handle situations with family. We go and talk about them.
So you handle situations by threatening other family members?
I didn't say that.
And you handle situations by threatening them and taking guns?
I did not say that either.
And you said that you didn't take a gun to Brianna's house. How about Gary?
Nobody had no firearms.
How about Derek?
Nobody had any firearms.
So you're telling this court you didn't take a firearm with you when you went to that house?
Exactly. I did not take a firearm with me when I went to that house.
But isn't it true that you are a convicted felon, Mr. Wilson?
Yes, ma'am.
For felon in possession of a firearm, isn't
Yes,
that
ma'am.
right?
Yes, ma'am.
And you say that your testimony is that you've never, you didn't have a firearm and you've never threatened anyone with a firearm, right?
No, ma'am.
But you also have a felony conviction for assault family second, don't you?
Yes, ma'am.
And those are all recent in the last 10 years, aren't they?
Yes, ma'am. But you know, it's an accomplishment to me. I know my mom proud of it. Ever since I was 16, I've been back and forth and out of jail. So for the last 5 years, I've been maintaining the appointment, and I have not, besides this case, been arrested at all.
And you don't want to go back to prison, do you?
Of course not.
You're going to say anything you can and make sure you don't have to go to prison, right?
No,
And you're going to accuse Brianna of lying, aren't you?
I'm just telling the truth.
And you're going to accuse Anthony Bagley of lying, aren't you?
I'm just telling the truth, man.
So when you went to Brianna's house, how far away were you living at the time?
I stayed on South Cross.
Did you stay in the master ranch apartments?
No, that's where my mother stayed.
Okay. So when Brianna called you, why didn't you go back when you knew the police were going to be there?
Brianna never called me.
Okay, so she's lying about that too.
About what? I don't get the
She's
question.
lying. So you're telling this court that Brianna lied when she said. Did she say she?
No.
Oh, in fact, okay. Let me ask you a different question. I apologize. So you heard Brianna testify that after you robbed her, you called her and told her to drop the charges. Don't do this, drop the charges. You heard her say that, didn't you?
Yes, I heard her say that.
Okay. So are you saying that that's a lie? You didn't in fact call her?
I did not call her.
That she's lying to this court by saying that?
Yes, she. Yes, no.
And so Gary, when this happened, Gary owed Anthony money for weed, right?
That's what I believe. That's the story I got from my brother. Yeah. But he had his baby mother had paid for it. And I guess they were still arguing about the situation, and Anthony ended up going to my mom's house.
Did you buy weed from Anthony also?
No, sir. No, ma'am.
You didn't?
Never bought weed.
What about Derek?
I don't know.
You don't know who he bought his weed from?
I don't even know if he bought weed.
And so when you went to Anthony's house or Brianna's house looking for Anthony, you were there to confront him, right?
Talk to him, make sure nothing happens to my brother, my little brother.
So you were mad that he had supposedly gone to your mother's house, right?
More like concern.
So if this was a family issue that you just wanted to resolve between the family, why'd you bring Derek with you?
Derek was already with me when I got the call. So, and he knew, and he went to school with Anthony. So, you know,
And you and Derek were good friends, right? So where's Derek now?
He's
That's some relevancy, just.
That'll be overruled. You can answer the question.
I believe he's in TDC right now.
And so he's in TDC right now because he took responsibility for this case, didn't he?
No, last time I talked to Derek, he had a pending case. He was on probation for 12 years. And I guess the state picked up this case And then he was in county jail for over like almost 3 years, 2 to 3 years, and he called me. We were supposed to take it to trial, and he just couldn't do it no more. Like he was ready to come home, and they offered him y'all offered him 8 years to run concurrent with his 12-year sentence.
Okay,
So
so Derek Alexander, what you're saying is that he pled to this case and he pled to 8 years in prison on this case, right? That's what you're saying.
I believe so, yes, ma'am.
So Derek Alexander took responsibility for this aggravated robbery. He admitted to the court that he was there.
Speculation, Judge.
Sustained.
You've been talking to Derek while he's been in prison?
No, ma'am.
And so Gary, you're saying that Gary, your brother, was also there when y'all went to Brianna's house? And where's Gary?
I'm sorry. I
Where's
didn't hear
Gary?
you, sir.
Where's Gary right now?
He's in county jail.
What's he in county jail for?
Do I have to answer that question, Your Honor?
If you know the answer, you
Relevancy,
just ask it.
Judge.
The relevancy will be sustained.
So, Mr. Wilson, when did you get arrested for this aggravated robbery?
I cannot remember the exact day.
I'm sorry?
I can't remember the exact day.
It wasn't the day it happened, right?
No, ma'am.
By the time you got arrested on this case, Derek Alexander had already gotten arrested, right?
Yes, ma'am.
So you knew about this case.
Yes, ma'am.
And so you've had since, when did you find out that Derek got arrested?
I cannot answer that for sure. I don't.
But so you would agree with me that you've had since June of 2018 or a few months after that, whenever you got arrested, to come up with your story, right?
No, ma'am.
To plan how you were going to try to deceive this court, right?
Objection, Judge.
What's
It's
the
argumentative.
Sustained.
So I guess, Mr. Wilson, what it comes down to is you're asking this court to, knowing that you're a convicted felon, knowing that you've had these charges pending since 2018, knowing that Derek Alexander has already taken responsibility for this case and gone to prison for this case.
Objection, argumentative is a compound question, Judge.
Sustained.
Knowing all of those things, you expect this court to believe your testimony.
Objection, relevancy, and argumentative.
Sustained.
I'll pass the witness.
Defense.
Nothing further, Judge.
All right, you may step down. Defense, call your next witness.
Defense rest.
State, any witnesses?
No, Judge. Resting close, Judge.
Repose.
All right, the court will hear argument. State.
Judge. Mr. Wilson, Mr. Alexander, and now we know Gary Clark went to Brianna's house on June 23rd, 2018, looking for Anthony perhaps, but ultimately what they did was rob her and they had firearms. Her 2 young children were in the house and they went into her house, went to her room and stole her money and placed her in fear, put her children in fear, placed all of them in danger by having these weapons. There is no reason, there's no reason for Brianna to be here in front of the court lying. There's been no evidence that would show a motive for her to lie about any of this. And the court has heard not only the testimony, the defendant is a convicted felon for felon in possession of a firearm and other violent assaultive offenses, but Derek Alexander, the co-defendant in this case, has already pled to this case and been sentenced to prison for this case. So we can infer from that that this did happen. Had this not happened, Derek Alexander wouldn't have pled to this case and would not be in TDC right now. There is no reason to believe Mr. Wilson's testimony over Brianna, who is not a convicted felon, who has no reason to lie. This trial has been dragged out for days, and what it comes down to is Mr. Wilson is refusing to accept responsibility for what he did. So based on all of the evidence that the court has heard, I ask this court to find him guilty because he is guilty, just like Derek Alexander was guilty.
All right, defense.
May it please the court.
Yes.
Although this case doesn't appear to be a kind of traditional case, and when I say that, Judge, is that this is a bench trial. And most times when we argue cases, is about the evidence and in the law. I imagine state kind of assume that, well, the court knows the law and the complaining witness has no reason to not to say the truth. That the state, I would imagine, has somewhat a lower standard because this is a bench trial. My position, Judge, is that the law still requires truth. I mean, evidence beyond reasonable doubt.
I'm sorry, Mr. You can just hold the microphone if you want to
Okay.
step in front.
All right, and Mr. Cox, if you would like to remain seated, that's fine. Or however you wish to do it. I know it's hard to remain seated.
Right, doing closing arguments,
Yeah.
Judge, but I'll try. So it's still truth beyond, I mean, evidence beyond reasonable doubt. Court heard testimony. There were what we did learn, officers come to the scene and they really don't conduct the crime scene in terms of investigation, because what is missing is that the victim, a witness, talks about, was a purse, and we have no photographs. The reason why there was special attention to some of the details in terms of whether anything was justice for prints or anything like that. Why? Because my client testified that he had never been in a house, never been in a house. Therefore, if, say, for instance, there dust prints, if his print was found in there, then that would be evidence that, hey, he's not being truthful. If you, in the court, I know recall testimony that the complaining witness, Mrs. Jungle, was kind of vague when I asked it. had my client ever been inside your house before, it was kind of, well, I don't believe he has. Or my position that she wouldn't know if he's ever been in there. Reason why we went with that line of question is because with testimony, she kind of says, well, they go directly to my room and go into the closet and go into my purse. That's a lot of assumptions for somebody that's never been to a person's home to just, not say, well, hey, where's the money? But just kind of know how to go directly to down a hall, directly to a room, go directly into a closet, and go directly into a purse. Question was raised, man, how many purses do you have? Well, she testified, I only had one purse. It's unusual. I only have one purse. They want to ask the question. Now her story is that it was just one purse that I used. I thought that's what you meant. And I think sometimes I'm not clear, perhaps, but I'm very clear on that point. The standard is still proof beyond a reasonable doubt. So therefore, we have Anthony back. He testified. Well, that he didn't talk to Ms. Younger at all about the case, but if he did, he spoke to her on the phone. That was yesterday. And Younger testified, well, if we made any mention of it, it wasn't on the phone. It was when I saw him in person when I went to pick up my key. It was yesterday. Baggy testified that, everything was a haze back then, and because I was on drugs and I don't have much of a memory of anything until the state asked him a question. And all of a sudden, yes, I agree. Reference her calling me, reference robbery. Then when I got him on redirect, it was, well, I was just kind of going along because it must have been what everybody was talking about. The standard is still proof beyond a reasonable doubt. State still has the burden of proof. And my position, Judge, is that I know the court will have an opportunity to whether the court make notes or listen to, and I know the court listen to the evidence in the case. My position is that the state has failed to meet its burden in this case. Prosecution mentioned, well, because somebody else did a multiple plea, therefore he must be guilty. The court has to find him guilty because somebody else decided to plea. That's not the standard. My position, Judge, is that when the state mentioned that, well, Ms. Younger didn't have a reason to fabricate part of the story. Well, if there's an argument about drugs in a house where you have young kids, that's a reason in and of itself. So my position, Judge, is that we just ask the courts to carefully analyze, review, deliberate. In this case, our position that the state has failed to meet its burden, proof beyond a reasonable doubt, and the court should acquit my client. Thank you.
Thank you very much. The court has listened to all the evidence. The court, as both parties know, closing argument is not evidence. So the court recalls all of the witnesses' testimony. The court does take notes, and the court has reviewed everything. And after reviewing everything and then taking in consideration all the evidence that has been presented to the court will find the defendant guilty. And so we will take him to custody, and then the court will set this for a sentencing hearing. And I will get a.
Bro, I didn't really, I didn't. Yeah, bro, I'm not going to jail, man. Boy, come on. I swear to God, I didn't know, bro. I'm not going, bro. Y'all gonna have to kill me. Mama, they gonna have to kill me, mama, because I didn't do it. No.